A very good afternoon, ladies and gentlemen. Welcome to this Inter-Pacific Bar Association webinar, which is hosted by the Legal Development and Training Committee, of which I am the chair, on educating transactional lawyers, a panel discussion on training lawyers for transactional practice. Wherever you're joining us from, thank you for joining us in this webinar. And I think that it will be a very interesting webinar for all of us, whether we be educators, students, or practicing lawyers in law firms. As a precursor and introduction, may I just perhaps introduce our speakers for this afternoon. We have, to start off with, Dr. Tung Rinarom from Chulalongkorn University Faculty of Law. Dr. Ram is a lecturer and Vice Dean of Academic Affairs at the university. He is a graduate of Beijing University, or I think probably pronounced as Peking University, China, and holds a LLM from Harvard Law School and a JSM and JSD from Stanford University. At Chulalongkorn University, Dr. Ram specializes in international law, law and business, and international economic laws, among the topics that he lectures in. Our second speaker for this afternoon is Ms. Ong Yi Ing. Yi Ing is a senior lecturer at the Singapore Management University in the Yong Pang Hao School of Law. Yi Ing also has practicing experience when she was a practicing lawyer at Milbank, Tweed, Hardley and McCoy LLP, which is an international law firm headquartered out of New York. At SMU, Yi Ing specializes in legal writing, ethics and social responsibility, corporate and commercial law. James is the Director of International Relations and Development and formerly an adjunct lecturer also at the College of Law Australia. James, I thought you still lectured there. Well, and
yes,
I know you do.
That's correct. Yes, I do.
Yeah. James is also an officer of the IPBA, where he serves as the chair of the Publications Committee. James has 15 years of experience as a corporate and financial services lawyer, working in a range of legal roles in private and public sectors. He was also, I don't know what he still is, but he's also a consultant in one of the leading law firms in New Zealand. Our final speaker for this afternoon, Dr. Jason Chua, is the Dean of the University of Malaya Faculty of Law. Dr. Jason specializes in private international and commercial and maritime law. Prior to his appointment, Dr. Jason was head of department and professor of commercial and maritime law at City Law School, London, the United Kingdom. Dr. Jason has been involved in various consultations with the Ministry of Justice in the UK, with the Organization for Economic Cooperation and Development, OECD, the ICC, amongst others. He has also served as a member of the consultative group on sustainable shipping for the United Nations Global Compact, and has contributed to the International Chamber of Commerce European Club for Counter Trade and Offset, International Good Practice Guide for Offsets. Now, with such a distinguished panel, which I'm personally delighted to welcome, and I must thank each and every one of them, because they are prepared to offer their thoughts, their views on something that as emotional as educating transactional lawyers. Now, I say it's emotional because this is something that very often we don't see it as emotional, but I think the various stakeholders, whether they be practicing lawyers, partners, associates, or educators like some of you, or if you're a young lawyer or even a lawyer that is not so young but aspiring to change from one limb of the law to the other one, then I think there is always something for someone to say. Now, to just have a very cursory overview of the legal education systems. Now, law school curriculum, by far and large, and teaching regimes are often litigation-centric and prepare students for a future career as a litigator. Law schools often teach substantive law and legal analysis skills through the study of case law, which is a method used throughout the course of the law degree study. However, though these litigation-centric methods often fall short in providing students with the necessary tools to navigate the complexities of transactional practice. Now, I took this from a reference an article written by Stephanie McMahon entitled "What Law Schools Must Change to Train Transactional Lawyers," which is published by Pace Law Review, Volume 43, in the year 2022. When curriculum focuses on case law and litigation, students are often taught to predominantly focus on the parties and their relevant rights and obligations, rather than interests and outcomes. As a result, students are often trained to view legal issues as solely isolated disputes with winners and losers, rather than understanding the holistic nature of the legal transactions and bringing into fruition the commercial realities and interests of all parties. The issues raised in this webinar are not isolated or jurisdictional or jurisdiction specific. Rather, these are global issues faced by practitioners and legal educators throughout the world. Tina Stark has mentioned in her 2011 opening remarks, published in the Tennessee Journal of Business Law and that transactional education in the United States, this is what she's referring to, is at that time 20 years behind the education of a litigator. In the present and in the developing jurisdictions in Southeast Asia and in Asia in particular, legal education in terms of transactional work may be even further behind this statistic that was mentioned by Tina Stark in 2011. Tina Stark also mentions that perhaps litigation skills training is more widely taught because it is more understood and more visible. I think visible is something that we all can agree with. Having watched lots of TV dramas, Suits and so forth, we see that we can understand what a lawyer does, or at least a litigator does. But very few of us can see the work of a transactional lawyer, and besides, the work of transactional lawyers do not make good drama series. I move on to practical skills. Many law schools frequently also host mooting competitions, yet they seldom incorporate hypothetical transactions where students advise clients on achieving business objectives within legal parameters learned from cases and statutes. Having said that, I stand corrected in terms of clinical education, which I think a lot of law schools are now beginning to adopt, not so much in mooting or from a litigation aspect, but from a client interview and trying to resolve client issues and problems. Now, most successful transactional lawyers are adept problem solvers with business-oriented mindset, comfortable with technology and interpersonal skills. They will possess project management capabilities, leadership qualities, and practical knowledge that add value to firms and deal teams. Now, insofar as the changing educational landscape, I must acknowledge that increasingly law schools and training institutes and academies are trying to change this litigation-centric case law method of teaching. Whilst it is acknowledged that there are regulatory restrictions in some of these, but I think by far and large, many law schools throughout the world are trying to achieve this. Now, I mentioned about experiential learning, and I think experiential learning was first originated from the very famous American educator John Dewey. Now, John Dewey in the late 19th century and the early 20th century articulated the idea of experiential learning in terms of the bringing real life experiences to enable a better retention of material that the students are being taught. Now, John was not the first, but John said this: a problem well stated is a problem half solved. And I hope that by today, we would not have solved the problem, but we would have at least embarked on a journey of trying to understand what the problem is throughout the world and how collectively we can try to resolve some of these issues. Clinical education, and insofar as experiential learning is concerned, is now, well accepted in, for example, in the University of Chicago Law School. They have a corporate lab. Columbia Law School, Harvard Law School, Stanford Law School, Georgetown Law School, to name a few. But these are all very American-centric institutions. I'd like to hear from each and every one of you as well as how your organizations are trying to incorporate experiential learning in the training of transactional lawyers moving on. So now it gives me great pleasure to invite Dr. Tungrin Ram to give his 10-minute presentation. Over to you,
Thank you very much, Mr. Tay, for inviting me to join this distinguished panel. I'm so glad to meet everyone, all the panelists, and also all the participants. As Mr. Tay mentioned, I'm now in charge of initiating a new program at Chulalongkorn University in Bangkok, Thailand. And this new program is called the LLB, Experiential Learning in Business and Tech Law. In short, we call it LBEL, LLBEL. EL stands for Experiential Learning. So that really answers to Mr. Tay's question about our approach to resolve this tension between educating the traditional lawyers versus educating the new breed of lawyers, transactional and more global lawyers. But before I delve into how our new program at Chulalongkorn is different from our traditional program, let me briefly explain some backgrounds about Thai legal education and about some obstacles that we face in educating transactional lawyers. First and foremost, I think we need to understand that Thailand has a very strong civil law tradition, influenced by the European legal culture, continental Europe, that really focus on educating judges, educating litigation lawyers, and educating legal scholars. So the focus on legal education mainly is on the theory, is on the doctrinal analysis, the doctrinal evolution of the law. It's really influenced heavily by the scholarly type of educators who have been educated in Europe, in France, in Germany, with strong civil law background. Most of these professors are full-time professors. They might not have much experience in practicing, not just in transactional law, but even in litigations. They are the scholarly type of professors. And this is the dominant type of professors that we have in law schools in Thailand. Now, with the increasing influence of American legal education and also common law legal education that focus more on the practice side of the education, as Mr. Tay mentioned, the rise of clinical legal education, the rise of moot court. So there's more emphasis on the practical sides of law within Thai law schools. In the past, it starts with our more emphasis on educating litigation lawyers. So we will have a course that actually provides basic building blocks for you to litigating cases in the court. We have the type of moot court training where students participate and also students join competition worldwide. But that's not enough. In recent years, as we have hearings from stakeholders in the legal field, we have heard a lot of complaints from our alumni in law firms, corporate sectors, that the law school have not prepared students to be ready, especially for this sector, the law firm market and the corporate market. And basically, as Mr. Tay mentioned, it's because our curriculum doesn't focus at all on the transactional side of the practice. We have very few courses on soft skills like negotiation. Students lack knowledge, not just on business law, but on businesses, on accounting, on finance. So not just that they should understand the basic laws regarding business, regarding commerce, but they also have to think not just like a lawyer, but also think like a businessman, or understand how their clients would approach these different types of problems. So with all of this, one thing that we have initiated is this new program called the LLB Experiential Learning in Business and Tech Law. And let me address the four features of the program that I think is quite distinct from traditional law program. The first feature, as Mr. Tay mentioned, is that this program is taught entirely in English. And we understand that we do not only try to educate the new type of Thai lawyers, but we want them to be global lawyers. We understand that increasingly corporate matters or international business matters have this transnational character. And then this new type of lawyers, they need to be fluent in English, and they need to also understand not just Thai law, but also understand the transnational aspect of business law and international business law, international economic law, so a more global view. The second feature is that this program is focused both on business and tech law. So interestingly, we do not just initiate a program and say that this will focus on business law, commercial law, but we also have this component of tech law because we really believe that in the next era, for transactional lawyers, they do not only have to understand business law, commercial law, but they also have to understand tech law and even basic technology and how to apply technology in the practice of law. These are two quite different things, right? One is tech law, which might involve, for example, PDPA, data privacy, which now really involve many aspects of the practice of business. But another aspect of this is also how to apply technology, data science, AI to help to aid the practice of transactional lawyers. For example, the rise of ChatGPT, how do we use generative AI in helping with drafting advice, in helping with drafting contracts. So this dimension of tech is very critical and very central to the design of the program and the curriculum. The third feature, which is also very distinct from traditional law program, is that for our students in the program, we combine both recent high school graduates, so undergraduate students, with recent bachelor degree graduates. So in Thailand, in the past, we have these two separate tracks. One is for recent high school graduates. They can come and study law in the LLB program. And they have another track, which is similar to the JD program, which is students who graduate from other bachelor degrees in engineering, in business, in economics, and they come to study law for 3 years. But this new program of ours, the LLBEL, we actually combine these two groups of students together. So we accept 50 recent high school graduates and we accept 10 bachelor degree graduates. For the 50 high school graduates, they will take 4 years of study. For the bachelor degree graduates, they will only take 3 years because they do not have to study general education courses. And these two groups of students, they will study together and they will have a chance to interact in class, to interact with people who already have background in business, in engineering, in economics. So it's more interdisciplinary in terms of design. The final feature and the most important feature is the experiential learning feature of the program. And there are a couple of differences for this program. First is that it's compulsory for all students in the program that they have to take a semester in their third year. So in their third year, in their second semester, all students in the program will be placed in a law firm. We have already signed an MOU with 12 major law firms in Bangkok to place our students for an externship for 1 semester for 4 months. This is different from our traditional program where students can just opt for summer internship and it's optional for them. They can choose to do internship or they cannot, or they can do other things. For students in this new program, which is very focused on educating transactional lawyers, it's compulsory for all students to do this externship semester in a law firm for 5 days a week. So basically, we have 1 semester for them to really do experiential work, really do practice trainings in law firms, because we understand that it's very different from just teaching laws in classroom. We can bring in practitioners, we can have them do project-based training, we can have them do clinical works, but it's very different than saying that we can press them in law firms and have them get the real experience during a semester during their 4 years of law schools. But besides this key externship semester within the program, we also, for every semester, we have designated compulsory skill lab courses. So basically, for each semester, there will be a course that's really focused on transactional legal skills. For example, in their first year, they will have to study legal research and writing. And then for their second year, they will have to start learning about drafting contract, negotiating contracts, doing transactional work. But we designate 1 course, especially for skill course. So this is different from saying that we have to combine skill training into traditional legal courses, because for that, it really depends a lot on the lecturers who teach the course. But when we say that we have a separate course focused on skill and also a compulsory mandatory course for all students, this is a very clear guideline for a professor who teach that course, that they have to develop a course that's really focused on skill-based training. And then for each semester, they also have to look at the curriculum of what students will learn at that particular semester, and then decide the skill course to tailor, to fit with the legal content, additional legal contents that students learn in their other courses. So these are 4 very different features of this new program compared to our traditional law program. And I think that for us, this is also a very important initiative in changing the law school curriculum from starting this pilot experimental program that I strongly believe in the future will also influence our traditional program, because now we also heard a lot of callings from people, students in our traditional law programs, that they want to also to incorporate some of these features into the traditional legal programs. So let me end my first round here, and I look forward to discussing more with all of you. Thank you very much.
Thank you, Dr. An. Ying, please.
Yes. Okay, I just want to make sure that my slides are showing.
Yes, it is.
Great, thank you. Okay, yeah, so thank you very much for that discussion about the type program. So I also, starting off from the same point, discussing some of the tensions that we face. So I've seen both sides of the equation, as it were. I used to be a practicing lawyer, doing M&A and funds work in cap markets, and then now I teach mergers and acquisitions. So I'm kind of seeing both sort of requirements from both sides. So you know, again, similar starting point. On the one hand, the profession tends to demand that the teaching and research we provide is deeply practical, so that we can have baby lawyers ready to hit the ground running, right? And all the firms would prefer that, and we've got multiple discussions with firms about what kinds of lawyers they would like us to train up. Right. But on the other hand, as academics, right, we have different sort of priorities in the sense that we're trying to train them to be thinking individuals, to focus on understanding the foundations and theories and things like that, ideally so that they will question and not just follow. Right. And of course, in academia, the pendulum has swung to prioritize research above teaching most recently, and that of course takes away our time as well and ability to focus on teaching. So that's sort of the basic foundation for this discussion. Now that said, in Singapore, we have had so many discussions on the way forward for training lawyers in view of all these developments that we have seen lately. And so the requirements are not just from transactional work, the requirements are for everything. And so I just present to you the recently released working group for reform of legal education. And their report says we have to do all these things that you see. So it's not just going to be transactional work, it's not just experiential learning, it's going to be, we have to learn civil law, we have to do ethics, of course, we have to do the essential skills, we have to do public sector work, and to be exposed to other disciplines. So we are now expected to incorporate all these requirements as well into our curriculum, right? So there's going to be a lot of demands on the students as well in terms of what they have to learn to be prepared to go out into the world. Okay, that said, in my school at least, SMU School of Law, we have very actively tried very hard to have more practice-ready students in light of, again, all these concerns that have indeed been raised by various stakeholders, right? And so we have actually come up with quite a lot of courses that we think would be valuable to students in the transactional world. And so we have in fact come up with something called the corporate transactions track, right? Where we go beyond the usual contracts, business organizations, corporate law, and we now require them to come up with some certain electives that you see there. They also have to take accounting, they have to take finance. You can imagine that you know, this is easier for some of our students than others, but if they want to say that they are, you know, a corporate lawyer, or they are prepared to become a corporate lawyer, then if they take these sequence of courses that you see here, then they will be able to say that they are, you know, sort of on the corporate transactions track, and that will signal to the employers that they are more ready perhaps to take on the requirements of being a corporate lawyer. Okay, I just wanted to add one note, since we're talking about experiential learning. We also have specifically experiential learning courses. So this is under the SMUX portion of things that we have. It's specifically where we move away from the traditional pedagogy of classroom teaching, and we are supposed to move them into more experiential learning, hands-on learning kinds of situations. So for instance, we have, I think, connections in law firms. And, you know, we have talks, we have discussions, we have also more assignments which more directly relate to what they'll be doing in work. So for instance, when I teach law and mergers acquisitions, I have negotiated simulations at the end of term, and I have a due diligence exercise for the students as well as part of their assignments. So these are some of the things that we are trying to do to engage some of those concerns that have been raised. So that's from the teaching part of things. That said, I think everyone recognizes that as from the point of view of the schools, there's only so much we can teach, especially in any particular specialization, right? And so, you know, some ways forward that, you know, that we could have for discussion, and I'm looking forward to hearing everyone's views as well, that we remove, that we sort of move away from the concern of have we taught them everything that they need to know in school, because I think that's going to be impossible, and the law changes every day anyway, and there's only so much we can do. That we focus perhaps on teaching them how to learn on their own, right? And I stole that phrase from somebody else, which is absolutely, I didn't come up with that, but the idea is that we teach them not just the transactional skills, the IP skills, the specific sort of skills that are required in any particular specialization, but we teach them how to acquire these skills on their own wherever they go, right? And that's more important than teaching them a particular set of content or a particular set of skills, because this is always going to change, it's always going to develop, it's always going to be something different to do. And then so I'm putting this out there for the lawyers out there. And one of the concerns that our students have definitely is that if we do all these experiential learning, what happens to their grades, what happens to their GPA, and we won't get hired. And so where do we have a discussion on what are the hiring requirements that the firms look for as well, so that the students are more willing also to experiment, right? And I also advocate greater cooperation between individual instructors and individual firms, and almost like how medicine operates. You know, how they don't have that divide that we tend to have here. So you're a clinician, you'll actually go to the hospital and you practice, and then you'll actually also teach in the faculty, right? And so there's a very up-to-date sort of teaching methods, teaching case studies that maybe they've just seen last week. And of course, from in the law, I think there'll be more difficulties for that for the law faculties. But we could, if we want to go down that road of greater experiential learning, greater sort of industry-ready lawyers, I think that's something that we could look at. And, you know, shout out to White and Case Singapore, who came and gave my students a 2-day workshop at their law firm, and the students went to the firms. They had some talks with the associates. They had, again, some negotiated simulations there, and they really enjoyed the sessions with the more hands-on sessions that they had with the lawyers there. Other things that we could think about, active mentoring of students, junior lawyers, even, you know, even legal clinics, right? And sort of in a way that the business schools have incubators for startups, SMEs. You know, we could even have legal clinics for startups, SMEs. I mean, I've seen personally that there are a lot of companies out there which they have great ideas, and, you know, you're always advising the legal advice, but they see us as a cost center, so they end up not getting any legal advice, and then they end up having problems later, right? So I think that's something that students, we could do little clinics for, that kind of thing that allows students to get their hands in as well and to really practice. Of course, I mean, I'm not saying that any of these are easy solutions, but you know, these are things that we could consider and start talking about. And then finally, I think that we also need to acknowledge that perhaps Gen Z has kind of different priorities and approaches to work, and I think we also need to make them part of the conversation as to what they think that they need from legal education. And again, I'm looking forward to hearing everyone's views on this. Okay, all right, and I think that's my sharing from me. Thank you very much.
Thank you very much, Ying. Thank you for that very informative input from you from Singapore. Can I now invite James Jong from College of Law Australia for his comments and his presentations.
Oh, thanks, Raphael. Thanks for inviting me to this webinar. Now, I'm just going to give you a very high level, my perspective on this topic. I won't go into too much detail. Now, I come from a corporate law background, so I'm not a litigator by any chance, no background whatsoever. But just talking from my experience as a student, as well as a lecturer in academia, I just wanted to share you my 2 cents for us today. Now, I think for most of us going into law school, you don't really quite understand the difference between a litigator and a transactional lawyer. So I think myself included, when I first went into law school, I thought that every lawyer would turn out to be someone like, Harvey, as you see on the suits, right? But as you get into your studies more and go into your into your electives, then you realize, you know what? There's actually a lot more than court work that lawyers do. And just to give you an example, the only time I've been to court in my entire life, and I've been practicing for 15 years now, is when I was admitted to the bar. Okay, that was the only time. And I think a lot of us actually don't realize that you don't need to be a court lawyer to be, a successful lawyer. So I think our law schools, now I think from my understanding, there are 44 law schools in Australia. And I think these law schools need to teach our students that, first of all, there is a difference between 2 types. And I think what's important, I'm just going back to what Raphael said, is that a lot of our law schools focus on litigation type of coursework. I'm not saying that's wrong, but I think a lot of us are kind of led to believe that this is the kind of the law work that's out there. And it wasn't really for me until I was in my kind of 3rd or 4th year last year of law school, I realized, you know what, there's actually a lot more to than being a court lawyer, and there are different career paths you can take. And I think it really comes down to interest and outcomes. Now, from my experience, looking at the litigation studies, the curriculum focus on case law and litigations, and students are really taught, focus on parties, their relevant rights and obligations, rather than looking at, interest and outcomes of your clients. And I think as a transactional lawyer, you need to really focus on learning what are the interests and outcomes of my client. And I think that's something that's missing. And I don't know if I can speak for all law schools, a lot from our, law school curriculum teaching academia. Now, I work at the College of Law, where we focus on teaching practical legal training. Australia being a common law system, I think studying law, doing your LLB or a JD degree is your first step into becoming a lawyer. Mandatorily speaking, you need to do your second part, which is a PLT, practical legal training. It's a 15 to 30 week practical training program, which is offered by, some of the law schools throughout Australia, as well as the College of Law. And this is where you're really looking to developing your practical day-to-day skills that you need to as an entry-level lawyer. And I think this is when I did my PLT, when I realized, you know what, I can now see clearly you can either go the litigation path or international arbitration or ADR, or you can really go into the corporate transactional path as well. So it wasn't then I really realized that, there's more to it. Now, and I think just to add a little bit more here, is that, to become a transactional lawyer, you got to first really teach understand the basics. But above that, and I think this is something a lot of law schools don't teach, there's a lot of the other interpersonal skills, or commonly we talk about today, the soft skills that's required as a successful transactional lawyer. So it's not about, as Raphael said earlier, having a winner and a loser. It's all about collaboration. And I think we should be teaching collaboration in our law schools. We're looking at what is our common goal, okay? So it means that two parties collaborating to find a common goal here. So it's not about winning or losing. So it's about these personal, soft skills that we should be teaching, or try to teach at law school to really bring out a practice-ready transactional lawyer. And I think for us, how do we do this? I think for us is to really employ a lot of adjunct instructors. These are the people who are in practice. And I think this is a common issue for a lot of the law schools. I might be wrong, is that, if you've been out in practice for so long, you're not so much up to date. And I think this was a common issue that we had from our organization, is that the law changes so rapidly. How do you keep up with it? Well, I think our solution was have all our programs developed and taught by practitioners. So this is how we go about in teaching, not just the legal skills. And I say technical legal skills, and I think you've said this before, Raphael, in many of our IPBA seminars, is that I think technical legal skills is probably a given nowadays. You've got to go beyond that. And as a transactional lawyer, you need all these soft skills, interpersonal skills, communication, problem solving, time management, all these skills that's essential in being a successful transactional lawyer. So I think that's something that we should focus on. And hopefully this will be something that we will soon embed into a lot of our law schools in Australia. But I'll stop there, and I know the other discussions and questions will go on. We'll talk more about this, Raphael. So I'll leave it there for now and take on any questions later on. Thank you.
Thank you. Thank you very much, James. Now, the final speaker, but not the least, of course, is Dr. Jason Chua. Dr. Jason Chua, the floor is yours.
Thank you very much. I hope you would excuse the noisy background. Unfortunately, the lounge has got a little busy than I expected. But I shall do my best in the next, hopefully about 8 minutes, if that's okay, Raphael. So I've got some slides to share, but they're very, very brief indeed. But I will be very controversial. I don't want to basically repeat what has been said, because I do believe that my colleagues have done an excellent job in handling the issues at hand. For me, I think the first point I want to raise is perhaps that which is encapsulated in my title, which is whether a more inclusive legal education, the plight of transactional law practice. Now, this is something that actually Ying had alluded to, in the sense that there are so many other imperatives out there. People want us to talk about technology. People want us to learn to give our students a flavor of public sector work. They want us to look at social justice, etc., etc., etc. And the problem we all have, of course, is a resource one. This, if you have a 3-year degree, you have a 4-year degree, a 5-year degree, these are finite degrees. And the problem with a finite degree is you can't cram everything into that finitism, if you like. So to me, the question is, how do we make our legal education much more inclusive, essentially? So that is perhaps, I hope, an intriguing start to my very brief presentation. So moving on then, I thought that perhaps I'll start with what all good researchers do. Again, Ying referred to the tension between research and teaching. And for my evil and sins, I'm afraid that I'm very much a researcher, though I do teach as well. But to me, starting with the problem statement is exceedingly important. And of course, I would not presume to be able to restate or state the problem in other jurisdictions, but I shall perhaps talk a little about the problem in Malaysia. And to me, it is a big problem. It is a big problem because of conservatism. And it is the fact that we do not look at an evidence-based approach to legal education. We look for knee-jerk reactions. We listen to, some judge talk about, oh, our students cannot speak English, and then we panic, and then we get into this, dreadful sort of conflict over, oh, what do we do then to improve English? And suddenly we want to introduce all manner of English programs into the legal curriculum. The next day, another prominent lawyer stands up and says, oh, your students lack social skills. We then again get into another panic. And I feel that this kind of knee-jerk reactions will simply cause law schools literally to pivot from post to pillar to post without actually creating anything that is sustainable as the legal education strategy. And I feel that, I know these are very so-called philosophical terms to be banding around out there on sustainable legal education, but I do believe in that. I think that we are laying the foundations for future generations of lawyers. But unfortunately, we are also very pressed by the demands of the day. So today, the flavor of the month is transactional law. Tomorrow, it will be something else. I promise you that it will be something else. I have been teaching law for 34 years and have seen it come around and around and around and around. And to me, therefore, we need to take on a much more long view of where we want legal education to go. And to some extent, therefore, I'm going to say something very controversial here. To me, I think that if we teach our students the ability to learn and the ability to respect knowledge, I think it will help us tremendously. The problem we have at the moment is my students tell me, what can I do to pass this paper? What can I do to get a grade, a top grade? What can I do to get into the top set of law firms out there? That is what they're interested in. And of course, as you know, market providers, we tend to respond to those questions almost verbatim, and we give them the kind of answers which I feel are somewhat irresponsible. Why do I say irresponsible? They are irresponsible because we are not actually teaching them or instilling in our students the critical essence of learning. So, to me, there is no real divide between practice and theory. There is no real divide between social abilities and social competencies and head knowledge. Really, to be honest with you, I mean, we have had the luxury of perhaps, a long established and, from what I can gather from my colleagues' biographies, an excellent set of credentials. You guys are very fortunate, but we do have many other students whom I feel that when we have a very selective program of only catering for, if you like, very small classes of students who can afford that high level of experience that we talk about, in the term experiential learning, what do we do with the masses? What do we do with the masses? Do we create substandard law schools for them so they can go and learn to practice other less glamorous areas of law? I really hope we don't get into that. To me, therefore, whilst it's important for us to stress transactional law to me, it's also equally important to respect the diversity in the legal environment that we inhabit. So to me, this conservatism, I think, has been, as has been stressed by some of my colleagues, it's actually shown by regulators. In Malaysia, we are so heavily regulated. It's absolutely stifling, I find. And then the profession, of course. Now, we also talk about, let's get the professions involved in teaching because they are the best suited people to do so. May I perhaps throw something very controversial out there? They may be the best practicing or best transactional lawyer you have, but can they teach? Can they teach? To me, it's also important. I mean, they have chosen legal practice over legal education for good reasons. Maybe it's money, of course. I understand that. I mean, I know what my salary is compared to, my fellow practitioners out there. But deeply embedded in that, I believe, it's also a belief that, when it comes to teaching transactional law or transactional law practice, however we want to phrase this, the prefatory word there is teaching. So if we don't know how to teach, there is no point in flooding the classrooms with lots and lots of practitioners. I'm sorry about that. I know that academics are perhaps not as good, well placed to teach these practicing skills, but where do we find that balance? To me, it's some transactional lawyer who is genuinely committed to legal education. That to me is the caveat. The academy, of course, there is big conservatism within the academy, and I don't need to stress any more about that. The students, and that to me is it's the big elephant in the room. I mean, I took when Ian talked about Gen Z, for example. Sorry, I can't say Z. However way I try will myself to say Z, I can't do so. But I find that sometimes we forget about them. We forget about them. We still take this very one-directional, unilateral delivery of skills. The classroom, that's the best place to do it, or online learning, or whatever we want to call it. It's always one directional. Perhaps that is not the right direction to take. Well, last but not least, I would just like to say a little about, how I have looked at this problem in my last 30 over years of teaching experience. What I feel is that, as I say, all these things are integrated, and let's not try to take them out and pitch them against each other, because I don't think that is the right solution. However, there are some deep values that we need to talk about. To me, number one, it's having to educate my students to move from a dispute resolution mindset to a dispute prevention mindset, from contract law to contract management, from mooting to business proposal pitching, from client interviews to business negotiations, from writing to contract drafting, from social justice to commercial justice, from clinical legal education, which we talked about a great deal, to commercial experiential learning. But these things are not mutually exclusive. Let's perhaps take that lesson away. And so this is what I'm trying to do at UN. I have no time to go into my last slide about what we are trying to do at the University of Malaya, but I shall share my slides and hopefully it will create some tantalizing reading for you. Thank you very much, Raphael. Thanks for having me.
Thank you very much, Jason. Really, I just want to congratulate each and every one of you, because I think you have brought to the table, to the narrative, to the dialogue, to the discourse, very, very pertinent, very, very exciting suggestions. And Jason, some of your statements may be controversial, but I think we all understand where you're coming from. And I think your prescription, despite the controversial warning, is really what we are looking for. To be clear, the focus of the discussion, to be clear, the focus of the discourse this afternoon is not whether a litigator can successfully transition into a transactional lawyer in the course of its career, or whether the teaching methodology of law schools is correct, or whether the weightage is right or wrong. I think, to be fair, many senior transactional lawyers began their careers as litigators, and through their passion, i.e., their willingness to learn, their ability to learn. I think Ian and Jason, you mentioned about ability to learn, teaching students the ability to learn themselves, have proven to be very, very useful to many of these transactional lawyers as they transitioned from litigators to transactional lawyers today. But today's discussion focuses on recognizing that the current law school curriculum is heavily skewed towards litigation skill sets. It's fine. That is what it is. But I think the importance today is to introduce the idea that perhaps the curriculum could be more balanced to include the teaching of transactional skills, to move from, like what Jason very eloquently spoke about, from mooting to business pitching, I think, a presentation. And I think that's what we are talking about, so that the students, our students, future students, and young lawyers have a flavor of the different skill sets required, and therefore make informed decisions in the future career paths. And also for young lawyers or young students who have chosen to be employed by international law firms or even national law firms to do transactional work. What does it mean to them? Are they properly equipped, or do they understand sufficiently the differences in order to appreciate their choice of career paths? So with that, I would like to throw one general question out, is that, are we all in agreement? Are we all in agreement? This is about problem setting and trying to figure out what the problem is. Are we all in agreement that law schools today have a bias towards litigation-centric syllabus? I think that's the first question. Can I just invite any one of you for your views, and why is that so, perhaps? James, you're laughing.
Thanks, Raphael. If I could just add my 2 cents worth here. Now, I think in Australia, I think that, this is just me personally talking. I think the trend is changing. I think with the new generation of students and whatnot, there's a lot more curriculum focused on transactional business focus at the law schools, rather than being heavily focused on litigation type of curriculum. But having said that, this is Australia that we're talking about. And I think the problem is, in the past, a lot of the academics came from a litigation background. So naturally, a lot of the curriculum was designed towards the litigation subject, advocacy litigation,
Good point.
and whatnot. But now I think we have a lot more transactional, commercial, corporate M&A lawyers coming into the academia, which bring that transactional experience into the curriculum. So I think the trend is kind of slowly changing. Talking about our own organization, we've got a clear elective section on transactional, commercial law practice for those students who wanted to do that. And we've got a large amount of, young, students and lawyers wanting to do cross-border transactional law, meaning they want to go into practice international law, meaning after I do my 3 years in Australia, I now want to go practice out in Singapore, London, wherever. So they know that they need that kind of experience. So I think the schools are slowly preparing, equipping students in that way. That's just my 2 cents worth there, Raphael.
Thank you, James. Thank you. Ian, do you want
Raphael,
to?
maybe I could.
Sorry, Jason, go on.
Sorry. Ian, go ahead. Sorry.
Yeah, I was just going to agree with James actually, because I think the schools are very aware of this need because we've heard so much, back from the stakeholders and the firms. And so we are working very hard to incorporate those skill sets. Now, are we fully successful? I guess that's a question that we have to ask the audience as well. Do you think that our education, that the what we're trying to do is working? So that's what I would like to hear from everybody else as well.
Jason.
Yeah, thanks very much. I think to me, one of the problems we have in Malaysia is that the law degree is considered to be a professional degree. It is unlike what you have in the United Kingdom, where it is a 3-year general law, liberal arts, law-based degree. Following that, you can choose to become a solicitor or a barrister through appropriate training. Whereas in Malaysia, if you call it a professional law degree, then you have to ask, what do we mean by professional? And then you have to, with that problem of definition, naturally we turn to those who shout the loudest. And unfortunately, those who shout the loudest tend to be the litigators in the Bar Council. I think we know who they are. And as a result of that, we end up having those who shout the loudest telling us what it means by professionalism. And then you ingrain that into your curriculum because we have a regulator that listens to the profession. And so we end up having what we have. But because the say that we have as educators is actually very limited. And of course, the transactional lawyers, I met with the president of the Malaysian Association of GCs. None of my students have even heard of the Association of GCs. And some of them don't even know what GC stands for. And yet this organization has no say, no seat in the legal professional qualifications board. They have no influence at all on how the professionalism of the law is to be defined in terms of regulation. So to me, that has to change.
Jason, I just want to thank you for bringing this up because I have been involved in the Bar Council for many years prior to this, and I know what you say is quite true. I mean, we may not want to admit it, but I think the legal profession in Malaysia is overwhelmed by litigators because of the nature of the structure of the profession. But I was just intrigued that you said that maybe some of your students have not even heard of general counsels, but that's unfortunately the truth, isn't it? Right. Do you want to respond to this? What we're discussing about this?
Yes, so it's quite interesting, Raphael, because when we do in Thailand, for example, we hold hearings from all the stakeholders in the legal profession. And interestingly, right, from people from the Court of Justice, they would say that we have not focused enough even on educating litigation lawyers or people who would be equipped in going to court properly. And then, if we hold hearings on the transactional lawyers, then they say we do not do enough in educating transactional lawyers. And it's, as Jason mentioned, right, who's the loudest voice. And it's quite interesting because the legal profession is quite distinct. For example, if we compare it to the medical profession, I think at least, doctors, they graduate, they all practice in different perhaps areas, but they are doctors, right? But for lawyers, it's vastly different if they have become judges, prosecutors, litigation lawyers, transactional lawyers, or international law scholars, or people working in international organizations. They all require different skill sets, different soft skills, different knowledge. And so one solution that I actually promote at the faculty is to have different tracks for different types of lawyers, right? So when you enter the law school, if you want to become judges, then you should select or these courses, you should do this type of training. If you want to become transactional lawyers, for example, introduce you to the new program that we have found. But we recommend students from the start that if you are interested in becoming traditional lawyers, for example, you want to go for judge exam, prosecutor exam, if you want to be litigation lawyers, then this new program, the LBEL program that I mentioned, is not suitable to you, right? And so I think that if we don't think of a law school curriculum as one curriculum, but as many different curriculums designed for different students who are interested in different things, then perhaps that's the way to go.
Thank you very much. You preempt me on my next question. Actually, I was going to ask then. We have identified the problem. That's half the problem solved. Now, how do we solve the rest of the problem? And that is, how would your law schools in your respective jurisdictions, or what can you do, whether alone as educators, or together with practicing lawyers? I hear what you say about having too many adjuncts that can't teach, Jason. I acknowledge that not everyone can teach. But what in your opinion can either your institution or your respective jurisdictions do in order to try to bridge that gap within the parameters of the law and regulations, of course? Anyone? Maybe Ying, maybe you can start, Ying.
Yeah, so I think again in Singapore at least, we try to work quite closely with industry, and I definitely agree with the statements that you're a great practitioner doesn't mean you're a great teacher, and I mean it's a skill that we all have to learn as well. But I think, as I said, I would really like more tie-ups, perhaps with individual lawyers, not necessarily to teach, but to have a discussion about what the curriculum they would like to see, what kind of skill sets they would really like to see our students come up with, how we can facilitate that, not just necessarily at the school itself, but at the firms itself. Maybe we can have some on the job kind of shadowing, practice workshops.
Ying, we lost you. Ying, we can't hear you. Okay, Ying, in the interest of time, can I just move on first? And I hope that you can continue later on. James, you want to say something, James?
Yeah, Raphael, I reckon there needs to be a better communication, not just from the law schools itself, but also the profession itself. Now, once students leave the law school, they need to continue. And I think the real learning comes from the right mentoring and training within law firms. And I think we need to pass on that message. It's your responsibility as a law practitioner to really help train and mentor the next generation of lawyers. Now, I just remember I was very fortunate to have a very good mentor when I started out. But on the other hand, I had some friends that are coming out of law school who got no training whatsoever. It's either you swim or, you float, or you sink. There's no mentoring. It was just like a part of a factory worker. They can easily replace you. So you shouldn't have the mentality. So I think it's important to really work with the profession and ensure that we've got these good senior lawyers who are able to mentor and train lawyers, next generation lawyers. That's just my short comment there.
Thanks, James. We have about 5 minutes left. Jason, I know you have a flight to catch.
Yes, so I'll keep this really brief. First of all, I think that if the profession, however way we want to define them, wants training in transactional law, they need to pay for it. So to me, it is not good enough just to rely on taxpayers to, pay for public legal education and then for them to basically say, well, you're not good enough, your students like this, your students like that. I think, if you want something bespoke, then come and talk to us. We're more than happy to design a bespoke program. That's number one. Number two, I think we need to think about postgraduate, because too much of the focus here is on undergraduate programs. And in Harvard, there is an LLM in corporate and transactional law. It's the only one, I think, in America so far. In the UK, we are beginning to follow suit. And I think that's a good step. But of course, master's programs cost money, and law firms have got to invest in that. If you are not law firms, I mean, in-house, you will have to invest in that. If your employee wants to take time out, pay for them to do so. To me, that is one way of doing it. It's got to be bespoke. It's got to be focused. Otherwise, you're going to be spreading yourself far too thinly. Sorry, Raphael, I have to go, unfortunately. So thanks everyone for your patience, and I do apologize.
Thank you, Jason. I hope that we will continue this discourse sometime in the future. Have a safe flight, Jason. You have any comments that you want to make follow-up as to what can we do better as law schools, as mentors, as lawyers to train younger transactional lawyers?
Well, I think that actually, when we introduced the new program, Raphael, I used to tell people that the name is actually quite important because we say that the name of the program is LLB in experiential learning. And it's quite interesting that even for professors who teach basic courses in this new program, when they heard that they have to teach in this new program that's focused on experiential learning, it seems that they think that they have an expectation of trying to incorporate, this type of project-based experiential learning, transactional experience within their classroom. And actually, I mentioned that in this new program of ours, we have designed a separate course for skill-based training. But actually, for the traditional basic courses, actually for all the basic building blocks of civil law, commercial law, they can incorporate transactional skills, transactional projects into the course. And we are so happy to find that professors, even our traditional professors who teach these basic courses, when they understand the purpose of the program, the expectation of the program, the mission of creating an experiential learning type of program, they also try to incorporate this transactional skills-based training into the traditional courses. So I think that's another way forward, right? If we promote this idea, if we try to say that, litigation lawyers, traditional lawyers are not enough in this day and age, but we need to also focus more on training these transactional practice skills. I think that if the message is widespread enough, then we'll get a lot more resource in the law school.
Thank you very much. That was very insightful what you suggested, that the name changes everything. Ian, can you just try and see whether you are audible now?
Yeah, can you hear me?
Yes, absolutely.
Yeah.
You want to finish your comments?
I think I was talking about more direct consultation. So again, not just like we want students with more skills, but perhaps more specifics and how we can then cooperate to develop those skills. So I think it has to be, I agree with all the others, like it has to be a two-pronged approach. It can't just be us doing it. We need that cooperation with industry. Yeah.
Yes, I think thank you very much to each and every one of you, Ying, to to James, and of course to Jason, who had to catch a flight. But anyway, thank you very much. Really appreciate your time. Your insights and your comments has been very, very useful. I think from IPBA's perspective, from being a practitioner, I think what you all said, perhaps said in different ways, was very important. That really the task of educating our young lawyers to be transactional lawyers is not meant to be left to the law schools only, but we all have a part to play as stakeholders. Now, before I end this webinar this afternoon, I just have one announcement, and that is the IPBA mentorship program. Now, the IPBA mentorship program, initiated by the Inter-Pacific Bar Association, is a program for young lawyers who will be mentored on a 5-month program entailing 5 hours of mentorship from senior professionals of the IPBA, members of the IPBA. And the focus of the program is for young lawyers to enhance their involvement, not just in professional organizations, but to have value-added access to networking and learning cross-border skills. Particularly after COVID, we have come to realize how important it is to have face-to-face meetings, and because all these things work towards completing cross-border transactions. So for those of you who are young lawyers, I believe below the 40 years of age, please go to the IPBA website and please apply for this mentorship program, which will begin, I think, in a few months' time. So please do that. So if any of your students are keen to do something like this, please also contact IPBA. We are quite happy to make some kind of arrangements for students. So without well, that brings me to 5:15 Singapore, Hong Kong time, Malay, Kuala Lumpur time. Thank you very much, ladies and gentlemen, for your time. I will summarize what has been taken, what we discussed this afternoon, and perhaps send it back to all of you so that it is talking points or points that you can take away with you for your further reference in time to come. So thank you very much, Ying. Thank you very much, James. Thank you very much, I look forward to meeting you in face-to-face one of these days. Thank you. Bye-bye.
Thank you, Raphael. Thanks, everyone.
Thank you very much. Thank you, everyone.
Thank you very much.